Hey, this is Jackie Hauser. Welcome back to Laughter in the Law. It's our podcast with Flexner Hauser Injury Law. And today I have a guest that's not Diane. Today I have Cam Simmons with us. Cam handles our workers' comp. He does all of our workers' comp for us. And so I wanted him to come in and talk to you a little bit about workers' comp and what workers' compensation is, what it is not. And so we're going to spend a few minutes with Cam talking about that. If you don't know Cam Simmons, Cam, I want you to introduce yourself. Tell our audience about your education and your experience.
Sure enough. And let me first apologize for my voice. I don't normally sound like this. I got a cold from my kid. So education, I spent 12 years in college because I loved it. Got a couple undergrad degrees, got a couple master's degrees.
Not because you really only spent 10 years. You spent 12 years on purpose.
That's right. I did. Exactly. Mainly to watch football, but that's another story. Got my law degree in 1999 from West Virginia University, moved immediately down to North Carolina, took the bar here, and have been practicing since roughly July of 1999, mainly in workers' compensation, did a little bit of personal injury in the beginning, but mainly this has been in workers' compensation for the last 20, 25 years.
Did you just kind of fall into workers' comp, maybe with your first job, or was it something you were interested in?
So I was a defense attorney. I fell into it. Okay. That's the quick answer. I was a defense attorney first, meaning that I would have represented insurance companies and employers against our present clients.
Exactly.
For about the first 6 to 8 years. And the defense firm I started with had you do both personal injury, which is what you do, and workers' comp to see which one you like the most. And workers' comp was just more of a fit for me. So I slowly left the personal injury side and started doing more and more workers' comp. Probably about 2001, 2002. I was almost solely a workers' compensation attorney at that point.
And so like me, you went from doing defense to doing plaintiff.
That's right.
Yeah.
Switched to the correct side of the V.
Got the white hat.
That's right.
That's right. And then at some point you got your specialization.
That was about 2006. So North Carolina, like not every state in the union does this, but North Carolina, to help people in the public understand who knows what they're doing and who doesn't know what they're doing, they provide specializations. And there's a couple of different requirements. One, you have to be practicing a minimum of 5 years. You have to show the bar, which is not the place you go get a drink, but the governing body of lawyers. You have to show them that a substantial portion of your practice is in the field that you want to specialize in. So for me, it's workers' comp. There's family law. There's criminal law. There's bankruptcy. There's a bunch of different specializations in New York. In North Carolina. And you also then have to take a test, very much like a board-certified orthopedist or a neurologist or a neurosurgeon. You have to take a test to show your competency. Right. I did that in about 2006, so I've been a board-certified workers' compensation specialist since then.
Yeah, so it's an advanced test beyond the bar exam where you become a lawyer. Then you have to wait that certain amount of time, meet those criteria, and then take that specialization test.
Correct, and not a fun test.
Yeah.
Very much like the bar. You recall the bar.
Right.
Not a fun test. Neither of them are very fun, but it does a really good job of parsing out the people who don't know workers' comp and getting them out of the specialization field.
Yeah. And then after you take the test, are there any special requirements to keep your specialization?
There are. I have to have extra. So we both have to have what are called continuing education hours, continuing legal education. I think it's 12 to 15 hours a year. So in order to keep my specialization, I have to take a certain number of CLE hours in my specialty, meaning in workers' comp, either by presenting workers' comp or by taking CLE hours. And I also, every 5 years, have to be renewed. Meaning I have to name a list of people that know how I practice. Usually they're defense attorneys or judges. And the defense attorney is the person across the V from us, the person who represents the insurance company or the employer. And the bar sends them questionnaires basically saying, hey, does Cameron know what he's doing?
Right.
And they have to rank me high enough in order for me to renew.
Right. So then if somebody came up to you in a grocery store or some public place and just said, hey, can you tell me what workers' compensation is? I think you're qualified to answer that question.
Well, hopefully. I guess we're getting ready to find out in the next 20 seconds.
Okay.
So what workers' comp is if you're at work and you're hurt, it used to be 120 years ago, you had to go into the courts of general jurisdiction, which is where Jackie goes with the car wreck and slip and fall cases, and you had to sue your employer for negligence. And it wasn't efficient. One, because it was taking 2 and 3 years to get to court. It was hurting the labor force both on the employee side because people were staying out of work longer than they needed to, and it was hurting the employer side as well because we needed labor back in the early 1900s. And so what most of the states did is create a separate commission. Ours is called the North Carolina Industrial Commission. A lot of across the states are called industrial commissions. And they created a separate body of law to deal just with workplace injuries. And it's a compromise. So a lot of when clients come in to me and they say, what do I get for workers' comp? The first thing I say is you don't get pain and suffering.
That's how it's different from bodily injury, from what I do.
It is. That's one of the ways it's different. Like the laws are completely different.
Right.
So that's another thing clients don't necessarily understand is workers' comp has its own set of laws, its own set of judges, its own set of everything. So Jackie and I, we don't go to the same courts. We don't go in front of the same, I don't have a jury. I have what's called a bench trial. But that was put in place back in the early 1900s, and basically it's a compromise. You in workers' comp, you get some benefits up front, but they take some benefits from you in the end, like main one is pain and suffering.
Right. But also with workers' comp, fault is not an issue.
Not at all. It's a no-fault system. So it's not a negligent system like you work in. So if you're at work and you're hurt and you fall within one of two categories, one's called an injury by accident, and the other's called an occupational disease. It doesn't matter if you as the injured employee are at fault. It doesn't matter if your employer was at fault. Mainly, there are some at-fault issues associated, but mainly it doesn't matter. Doesn't matter who's at fault. You get benefits if you're hurt at work.
Yeah, so many times whenever folks call in and that initial call, they're very adamant, I wasn't at fault.
Doesn't matter.
And they almost breathe a sigh of relief when I say, doesn't matter. Let's move on to the next point.
That's right.
What are some examples of occupational diseases that would be covered under workers' comp?
So occupational diseases are definitely the smaller portion of most workers' compensation cases. Most compensation cases are called injury by accident cases. But an occupational disease is very much like if you work in a cold environment, like a hog processing plant here in North Carolina. They work in very cold environments, generally with a vibratory knife in their hand, and they're doing the same repetitive motion over and over. And a lot of them will get carpal tunnel syndrome.
Okay.
Occupational lung diseases don't have as many anymore that we used to have, like black lung with coal miners or silicosis, white lung in the garment industry, the cotton industry. Those are all occupational diseases. It's less of an acute event and more of an accumulation of problems over a set period of time.
Gotcha. Okay. Interesting. So you can't point to, like with injury by accident, you can't point to this is the day that my wrist started hurting.
With an occupational
disease.
Correct. It usually triggers by when the doctor tells you have an occupational disease. That's your injury date.
Okay. All right. So how would the average person know, average worker going to work every day, doing the 9 to 5, how do they know if they have a workers' compensation claim? What are the things that we are looking for whenever they call in?
First, your employer has to have 3 or more employees.
Okay.
So if it's just you and another guy, then you're not covered by the Workers' Compensation Act, but you can then sue under the negligence theory in the courts of general jurisdiction. But mainly the easiest thing is, was I at work when I had pain? Now, that's not necessarily a winning argument, but that's the first way to know. Was I at work when I slipped and fell and hurt my back or my shoulder? Was I in the parking lot that my employer owns when I slipped on ice and hit my head? That's real, and it's pretty intuitive, right? Were you at work? Did you have an accident? Do you have pain? Are you now hurt? If so, you probably have a workers' compensation case.
And what does the employee need to do at that point?
So you immediately tell your employer.
Okay. Got to report it.
Yes. In writing, I tell all of my clients, talking to people on the telephone or in person is not good evidence. What's good evidence is emailing or texting your employer and saying, hey, fell in the parking lot, hurt my shoulder. Where do you want me to go to the doctor? And then let your employer say, we have a workers' compensation system. Here's what we have to do next. We have to file it with our insurance company because most of the dealings are going to be with the workers' compensation insurance company, not necessarily your employer. But early on, you report it and you go to where they tell you to go and you get diagnosed. What's wrong? And how long is it going to take me to get better?
So does everybody who gets injured in a workers' compensation claim or in a workers' compensation situation, I'm employed, I'm at work, and I get hurt at work, do I automatically need an attorney?
No. But here's the big but. The insurance company guys knows what they're doing. And they do, no matter how nice the adjuster is or how nice your employer is in the beginning, they're not watching your back. They're watching their back. So, and I tell clients this all the time. If you get hurt and your employer and the insurance company, because there's two of them, right? Employer and their insurance company. Those are the two people you're, for lack of a better term, fighting. If they accept your claim, they pay you benefits and everything is fine and you recover quickly and you go back to your old job and you're fine, you don't need an attorney. If any of that doesn't happen, you do. And here's the big problem, Jackie, is a lot of folks think they can, well, hey, my employer's going to take care of me. I've been here for 17 years. The insurance adjuster was really nice to me. I think she's going to do me right. And they get too far in and they've done some things that damage their claim, and then it's much harder for me as the lawyer to right the ship. If you come to me early, specifically before you start giving statements in writing or before you start giving statements to the insurance company, because they want to take what's called a recorded statement, what happened, when it happened, what were you doing, who was there, who saw it, all those kind of things. Those can be very damaging. Because as the injured employee, if you haven't been through the system, you don't know what the right and wrong answers are.
Right.
And you may say something that seems very innocuous to you that really damages your case.
And you made a good point there in that we're talking about two different entities. Your employer may be the best employer in the world, but you're dealing with the insurance company.
And they can be evil. You and I both represented them, Jackie.
We do. Evil is just one letter off devil.
That's right.
So
they are not trying to help you in general.
Absolutely. They do not have your best interests at heart.
No, they're trying to collect premiums and pay out less than they collect. And the way they do that is sometimes to compromise an injured worker.
So a lot of times employees, their fear is that because somebody's planted it in their brain, if they hire an attorney, they're going to get fired.
Or if they file this claim, they're going to get fired.
Wonder where that thought comes from.
Certainly not their employer, right? Or the guy who works next to him, whose brother's cousin's husband got fired when he filed a workers' compensation
And the adjuster
case.
would never tell them that. I'm sure that wouldn't be ethical.
Not during the recorded statement, they won't.
Absolutely.
But listen, guys, it's true. Now, there are some really good employers out there. Like the state is actually a pretty good employer to their employees. There are some bad ones out there that I'm not going to name, but I know who they are. But if you sometimes it's not even just filing the claim. If you get hurt at work, all of a sudden you're getting written up for all these things you never got wrote up for before.
Right.
And now you're late where you were never late before.
Right.
And so it's easy to tell that they're just lining them up to be fired. And unfortunately, Jackie, there's nothing in the Workers' Compensation Act, which is our body of law that governs workers' comp. There's nothing in the act that protects the worker from being fired. Now, there are other employment law claims that can be filed that I don't handle, but I have people who will handle them. But a lot of folks think, well, I was injured at work. I'm untouchable now. I can't be fired. That simply is not the case.
Yeah. Like I know we had a case one time together where the employer had this slew of people working for him, but everybody was managers. Everybody was, we're not hourly employees, so everybody had to work 40 plus hours a week, and we just knew that was not, that's not kosher. That's not, and that's a violation of the employment law. Everybody can't be a manager.
Or an independent contractor.
Or an independent contractor.
That's a big hit in workers' comp especially in the construction industry.
Right.
The employer doesn't want to be an employer. They want to be a contractor, and they want all the people who work for them to be independent contractors. And here's why. Because if you're an independent contractor, the Workers' Compensation Act does not apply to you. You don't get workers' comp benefits. So I've had construction companies that had 40 independent contractors working for them, even though The boss told him when to show up, when to take lunch, when to go home. He provided the tools. He told him what to do and how to do it. He provided supervision.
Right.
That's not an independent contractor relationship. And regardless of what tax form your boss files, that doesn't make you right. If he gives you a 1099, doesn't make you an independent contractor. The law says whether you're an independent contractor or not. And so a lot of folks will get booted out of the system that way, and they just won't challenge it. They're like, well, I guess I'm an independent contractor. I can't collect comp. I can tell you that the courts in this state are not real favorable to the independent contractor argument.
Right.
They want people to be employees.
And so those folks could have a workers' comp claim as well as an employment law claim.
That's right.
Which, of course, we could help them with both. You could help them with the workers' comp claim, and we have contractors that can help us with the employment law claim.
That's right.
That you know and I know as well.
Yeah, and the other thing is Jackie and I do a very specific body of law, right? I am just a workers' comp attorney. Jackie just does personal injury. Oftentimes, there are other peripheral cases that are related to my workers' comp case or related to your bodily injury case. The good news is, and I've learned this from my sister and brother-in-law who are doctors, and that is, if you want to know who the good doctors are, ask another doctor. Mm-hmm. Don't look up in the yellow pages, or we don't have those anymore. Don't look up on Google who's the good doctor, who's advertising the most.
Right.
Ask another doctor.
Mm-hmm.
So if you want to know who a good lawyer is for an ERISA claim, which is an employment law claim, or a RETA claim, which is an employment law claim, or sometimes we have clients who get in trouble and they need a good criminal lawyer.
Yeah.
We're the better party to ask because we know generally who is good, or we can find out generally who is good and who is not good, versus you just looking someone up on Google and saying, well, I like their name, so I'm going with them.
Right. Or they were at the top of the list.
That's right.
I'm going to go with them.
Right.
That just means
a lawyer.
Or they spent the most money on ads.
That's right.
So, hey, I spent the most money on ads. I get to be at the top of the list.
So even if we don't do it,
right,
we can get you to someone because we generally will know who is good at doing that thing you need.
And clients ask us all the time. I mean, I had a client the other day email me for something totally. She knew I didn't do this area of law, but she needed help, and I don't mind doing that at all.
Yeah, I constantly get that email. I like
referring my clients to good people.
That's
and
right.
Making sure they get taken care of. So let's talk about some scenarios, and we'll wind up here. I appreciate you coming in and spending the day with us, though, even though you're sick. You look really good to be sick.
Thank you. I'm trying. I'm holding it together, Jackie.
You are appropriately drugged for 30 minutes.
That's right. The Benadryl is kicking in.
Okay. It's going to get good once the Benadryl kicks in. All right. So what if you're injured on the job? You're an employee. You're injured on the job. You met all the criteria, and you tell your boss, and they won't send you for medical care. They say, I'll get back to work.
Not uncommon. Go on your own.
Okay.
Hopefully you have health insurance, whether it just be private health insurance, Obamacare, Medicare, Medicaid. A lot of people are afraid to treat on their Medicare or Medicaid because it's a workplace injury, right? They won't pay. Mm-hmm. A lot of my clients are afraid to treat on their private health insurance because they think, well, health insurance isn't going to pay because this is a workers' compensation injury. Mm-hmm. They're contractually obligated to pay. So if your employer is not sending you to where you need to go, you go on your own. You go to the urgent care. I would suggest you stay out of the emergency room. All their job really is, in my opinion, is to make sure you're not dying, get you out. Right? Because they have people who are dying coming to the emergency room.
That's why we use the word emergency.
That's right.
That's right.
Maybe not an emergency. So we even have urgent care sports medicine clinics now that are staffed by orthopedists. Mm-hmm. So we have things called MedAC here in town, urgent cares, orthopedic care, Emerge Ortho, which is one of our bigger orthopedic practices, has their own walk-in clinic.
Right.
Go to those places. Mm-hmm. You'll generally see a physician's assistant or a nurse practitioner, but you got to go on your own, right? You have to take control of your case. Don't sit around and wait for your employer to do the right thing. Don't sit around and wait for the insurance company to get involved because sometimes your employer isn't going to file the claim because they don't want their rates going up. So they'll tell you, hey, I'll take care of all this. I'll pay all the medical bills. Let's just keep it under the rug. And that generally works for about a week until an MRI is ordered or something expensive is ordered. And then all of a sudden your employer forgot that they were going to do all of that for you. But you, as the injured party, you have to take control of your case. And
sometimes there's these employers who haven't paid their workers' comp insurance. So.
And that's a problem. And that's a problem sometimes as a lawyer. I'm not able to take as many of those cases because I've had cases that I've fought for 2, 3, 4 years with what's called an uninsured employer. And I can get a giant award from my client, but you can't squeeze blood from a turnip.
Right. Yeah.
And which means that paper's worth nothing.
Yeah.
Even though it has a bunch of numbers on it that really favor my client.
Yeah.
If you can't recover, you can't recover.
Yeah. And hopefully, hopefully as an employee, your boss is unscrupulous before that, because that's probably not the only place where they're not paying things.
That's right.
Yeah. So last scenario here, what if your employer, what if you get a note from the doctor that either says you need to be on light duty or you need to be out of work, but the employer says, nope, you got to be here Monday morning, 9 o'clock, we open and I expect you here.
So all of these are questions that if you don't already have an attorney, you probably should get one.
Exactly.
One of the ways that I add value to a case best is the return to work scenario, because there are a bunch of hoops that your employer and the insurance company have to jump through in order to get you back to work. And guess what? The injured worker doesn't know those hoops. But so my first response would be, if you're getting that from your employer, you should already have a lawyer in your pocket. If you don't, you should probably get one. Whether it be Jackie and I or somebody else, you should have someone who knows what they're doing on your side to clear that way for you. But ultimately, Jackie, the doctors kind of rule the day in workers' comp. So if the doctor says, I think John can go back to work in a light duty capacity, which is generally lifting no more than 10 pounds, and the employer says, hey, John, I have a job for you. It's not your regular job, but I have a job for you to kind of get you through. Then there's at least an average chance that you should go back. But again, you should have a lawyer before you do that, because again, there are a bunch of hoops. They may try to put you in an off-site place to do this light duty job, which is not permissible in North Carolina. You should have a lawyer to help you through that process.
Last topic, and then we'll wind it up and you can get back to bed.
Perfect.
I sound horrible. I've pulled you out of bed on a sick day, made you put on a suit and come and do a podcast. And that's just
no worries. I talk all the time. It's my favorite thing.
You probably talk in your sleep.
I do.
Let's talk about third-party benefit claims, or third-party claims.
Sure.
Now, that sounds real fancy if you don't know what that is, but that's basically whenever you and I are both handling the same claim for one client. You have a workers' comp claim, but this person got injured in a traffic accident or by somebody else's fault, some unrelated person's fault, and so they also have a claim against that person. How does workers' comp work, and how do we typically handle those cases?
Right, and almost always it's going to come from a motor vehicle accident. That's probably 70 to 80% of when you and I work together on a claim, where it comes from. And third party, I talk to my clients all the time about third party claims. They're like, well, what is third party? It's just when you're suing someone else for hurting you, versus like a first party claim would be if your house got damaged in a hurricane and you have to sue your own homeowner's insurance. That's a first party claim because it's you. Third party is somebody else. And so what happens in a workers' compensation case, say my person is a school bus driver, and we have these claims. Driver gets hurt in a school bus accident. Driver has two claims, two completely separate claims that are tethered by one statute, which is a piece of law. They have the workers' compensation case because they were at work driving a school bus when they were hurt in the motor vehicle accident. That's the case that I would handle. Then they have a motor vehicle accident case, the third party case, which is the case that you handle. And again, they're separate bodies of law. There's separate damages available in each. If they're settled separately. But there is a connection between the two of them. And that is the law, the Workers' Compensation Act, Chapter 97 of the General Statutes, which is what I go by, says that if you settle the third-party case, if you settle the case for my bus driver against the person who caused the accident, let's say you get $50,000, and workers' comp has paid out money, they have the right to try to get some of the money back from that $50,000. And sometimes that's hard to explain to clients, like, why are they taking my money? And the reason is because workers' comp, the no-fault system, workers' comp didn't cause the accident. The other party, the person who ran their stoplight, caused the accident. So what the law says is, well, workers' comp then is paying for someone else's fault. And that's the reason why workers' comp is, I'm not saying they do, because you and I have ways to work around this.
Yeah.
You and I have ways to try to minimize the amount of money that workers' comp is able to get back.
We do.
But this is why you need a lawyer, folks. They will tell you, I get all of my money back, right? If workers' comp if you settle for 50 and workers' comp has paid 70 in benefits,
Yeah.
they'll tell you they get all 50 of your money back.
Yeah.
And that's simply not the case.
That's not the case.
Right. But they have the ability to try.
Yeah.
And that's where you and I work together to keep them from
Yeah.
getting most of that money.
Yeah. They love to, once again, if you don't have a lawyer, you got to believe what you're being told.
You don't know.
That's right.
And it sounds truthful, right? They may even quote some law for you, throw a case law or a statute in there.
Yeah.
They know. The problem is, Jackie, is the insurance company knows what they're doing.
Yeah.
And most of our clients do not.
Yeah.
And that's where you and I come in.
And regardless of how nice they are, very nice.
They'll be nice in the beginning,
Charming.
but mean in the end.
They are charming as they can be as they are ripping you off.
That's right.
Especially in, now not always in workers' comp, but the best adjusters are the charming ones because they can charm you right into giving up a bunch of benefits.
Not hiring a lawyer.
Exactly. So, closing thoughts, anything that you think is really important that we haven't talked about or that you want to stress that we have talked about?
I'm going to reiterate what we said in the beginning. And if everything goes perfect in your workers' compensation case, you don't need me. The problem is that doesn't happen very often. And the farther you go in your case without hiring a lawyer, whether it be me or another board-certified specialist, the harder it is for me to get you out of the mess that you've made for yourself. So, I mean, I would love it if injured workers came to me on day one and said, I got hurt this morning, here's what's happening. And sometimes I tell them, you don't need to do anything yet. You don't need me yet. But in a week, if you're still hurting, call me back. But don't do this, that, and the other. Don't give a recorded statement yet. Don't give a written statement yet.
Yeah.
And then ultimately, I would rather get involved early rather than later. If I can steer the ship early, it's better.
I'm going to ask you one follow-up question to that. Does severity of injury have anything to do with how soon they need to hire you?
Yeah, the more severe, the problem is you don't know. The more severe the injury, the quicker you should have counsel.
Yeah.
Early, or day two.
Yeah.
And maybe it's your family. Tell your family, if I'm hurt at work and I'm in the hospital, call somebody.
Yes, exactly.
And we go to hospital rooms.
Yeah.
When
we're called.
That's right.
No, we don't chase them
We
down.
come out on Saturdays.
But when we're called,
If
absolutely.
you call and say, I need you to come in, we'll go because it's better to have representation early than late.
Yeah, yeah. Well, thank you so much, Cam. I really
Absolutely.
appreciate it. You're a trooper. That's all we have for today on workers' comp. We could probably talk for hours, but Cam's medicine's wearing off. So
Or kicking in.
So that's it for today for Laughter in the Law. Thank you for tuning in. We try to talk about the law with a lighthearted twist.